Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're continuing with our 10-part series entitled the QME Top 10. The QME Top 10, and this is actually session number 6. And in this series, we're talking and tackling what seem to be the 10 most common questions, concerns, issues, confusions, misunderstandings, and frustrations that are facing qualified medical evaluators in 2016. And we're actually more than halfway through our series. Today we're on session number 6. And in today's session, which is entitled the Causation, AOE, COE determination in a denied claim, I have for you a fascinating series of topics and ideas to share with you. And I'm certain that by the end of this discussion, it's going to be a mind blower for you. The reason I can confidently say that is because I know for fact that many doctors do not understand the subtle and profound nuances with the ideas and labor codes that I'm going to share with you today. And I know that because I speak with many doctors on a daily basis. And I even have to admit that up until a very short time ago, it's almost embarrassing to admit this, but up until a very short time ago, I myself did not fully understand these ideas. And I did not fully understand my role as a qualified medical evaluator in a denied claim. I did not understand the AOE, COE determination of these specific and unique classes of evaluations that we do in the instance of a denied claim. It's a unique subset of the entirety of the work that we do, and I have to admit, I just did not have the awareness of how to handle it, which is even more surprising because I admit that about 2 to 3 years ago, I attended a lecture on this very topic, and it was explained to me in brilliant detail by the venerable Judge David O'Brien, one of our great workers' compensation and QME educators. And I listened to Judge O'Brien explain about Labor Code 5402 and Labor Code 4060, and I'm going to share both of those with you today. And he explained to us how claims come to be denied, and he talked all about the causation analysis. But I think what happened is that Judge O'Brien explained these labor codes and explained these rules and explained these ideas from the perspective of a workers' compensation judge, from the perspective of a workers' compensation defense attorney. And Judge O'Brien does indeed currently work at a defense law firm. And so after I heard the lecture, the ideas went to the back burner and went totally out of my consciousness. And I continued about my work doing pretty much what I had been accustomed to doing. And I continued to make what later turned out to be some mistakes. And I made some errors in judgment, and I made some opinions and determinations in my reports that later turned out to be incorrect. Has that ever happened to you? Have you ever actually found out, maybe a year, 2 years, 3 years after you've issued your report, that your opinions and conclusions were actually incorrect? Well, that started happening to me, and it sparked a dormant synapse from the Judge O'Brien lecture. And I reviewed the material regarding denied claims, and I reviewed the material regarding AOE, COE determinations, and I reviewed the labor codes 5402 and 4060, and I had a revelation of understanding. I want to share that revelation of understanding with you today, because I know in speaking with many doctors that this is an area that they have no understanding of. So I have a fabulous program for you, and it's going to take 2 sessions to cover this material. Today in session 1, I want to just lay the foundation and the framework for our second discussion. Today, We're going to talk about Labor Code 5402, Labor Code 4060, and we're going to talk about some of the reasons as to why, number one, the claims administrator would reject or deny or delay a claim. Some of the reasons, some of the red flags that the claims administrator becomes concerned about. And then secondly, I want to talk to you today about, okay, so when we get these examinations, what's our role? What's our role as the Qualified Medical Evaluator in examining these injured workers who are under a denied claim? What's our role? It's much different than our role when the dispute is over, say, for example, permanent impairment, or when the dispute is over, for example, the permanent and stationary declaration. In these instances of a denied claim, the dispute is over compensability. Compensability. Did an industrial injury occur or did it not occur? The reason the claim is under denial and the claim is rejected is because in actuality, no matter how you sugarcoat it or how you phrase it, the claims examiner is not convinced that an industrial injury actually occurred. And in a small subset of those cases, a small subset, not all of them, but a small subset, a medical determination from us as a qualified medical evaluator is required to resolve the dispute. Not in all cases, but in only a small subset of those cases are we required to resolve or to provide a medical determination that will assist in the resolution of the dispute over compensability. So we'll talk about those two topics in today's discussion. And then in our next discussion, I'm going to show you an algorithm that you can use in interviewing your examinee who is under a denied or rejected claim. And the purpose of this algorithm is to resolve the occurrence or the non-occurrence of an industrial injury so that you can provide your opinion and that your opinion can be correct nearly 100% of the time. Nearly 100% of the time, your opinion can be correct if you follow this algorithm. And trust me, I've learned this algorithm through the school of hard knocks after opining incorrectly and learning about it later more times than I care to live with and more times than I even care to admit. So you're going to be the beneficiary of learning from my errors and omissions over the past 2 decades of doing qualified medical evaluation. So I have a fabulous program for you. And for today's session, we have a couple of references that I want you to go ahead and print out. They are the references for Labor Code 5402 and Labor Code 4060. I'm going to want you to have those in front of you so that we can go over those labor codes, and I want to make sure that we have perfect understanding of how those labor codes impact the QME panel process as it relates to those claims that are rejected or denied. So we'll take a minute break here while I go ahead and get those references, and I want you to go ahead and get those references as well, and then join you right back here in a couple of moments as we begin the first part of our 2-part series entitled the AOE COE Causation Determination in a Denied Claim. Okay, I'm back with you now. now, and I have my two references with me. I hope you have your references with you as well, because I want you to follow along with me. There's way too much here to be able to memorize, so it's important that you lay your own eyes on these labor codes as we review them. And we're talking about the Qualified Medical Evaluator's role in the specific examination that involves an examinee who has a denied claim. Now, you can tell you're dealing with this type of circumstance when your evaluation comes reasonably close to the date of injury. As an example, just today, I received a request for a QME examination, and today is February 2016, February 18, 2016, and the date of injury of this particular examinee was October 15, 2015. So that's October 15, November 15, December 16, January 15, February 15, today's February 19. So this is an examination occurring within 4 months of the date of injury. Now, typically, when we are called in to resolve disputes related to permanent and stationary, permanent impairment, apportionment, those examinations occur years, years after the date of injury. At least a year generally, would you agree? Sometimes a year and a half, sometimes 2 years, sometimes 3 years, but much greater time has passed to allow the examinee to go through medical treatment, medical investigations, surgery, what have you. But you can tell you're dealing with this specific circumstance when you're dealing with a date of injury relatively proximate to the date of your examination. So that's one clue. Another clue is when you get a request for a QME examination, ask the requesting party, what type of examination am I doing? I don't know if you know this, but when the parties request a QME panel, there's a series of check boxes at the top of the form that allows the requesting party to indicate the type of evaluation that they're ordering. And they're only ordering one of 3 different types of evaluations. They're ordering an evaluation under Labor Code 4060, 4061, and 4062. Those are the 3 labor codes that govern the QME panel process. Well, it's Labor Code 4060, which we'll review here in just a minute. 4060 that governs the evaluation process when the dispute involves compensability. Compensability. Whether or not an actual industrial injury exists is called a compensability exam. So you can simply ask the requester, what type of exam am I doing here? Am I doing an exam under 4060, 4061, 4062? What's my role for this evaluation? Okay, and we'll review Labor Code 4060, and we'll clarify our roles in this unique circumstance. But before we even get to Labor Code 4060, I want to review another labor code that is going to serve as the preamble to Labor Code 4060, and will give you some understanding as to how these denials occur and how it is that disputes over compensability most commonly arise. And let me just ask you, why and how could, would, or should there be a dispute over compensability? Why and how could, should, or would there be a dispute as to whether or not an industrial injury occurs, or has occurred, or has not occurred? Why would there be a dispute? Well, there's many reasons for that, and I'll share the large preponderance of those with you as we review this code. So this is Labor Code 5402, and this explains it all. So follow along with me here, and I'm going to read the entirety of Labor Code 5402 to you, and this is going to give you a great understanding. Okay? So this is Labor Code 5402. It starts out by talking about what qualifies as a report of injury. Okay? What qualifies? So it says that knowledge of an injury obtained from any source on the part of the employer, his or her managing agent, a superintendent, a foreman, or other person in authority, or knowledge of the assertion of a claim of injury sufficient to afford opportunity to the employer to make an investigation into the facts, is equivalent to service under Section 5400. So what this says is knowledge of an injury on the part of any person in authority at the company constitutes service or notification or reporting of the injury under Labor Code 5400. So what this means is that if an injured worker wants to make a claim for an industrial injury, their first step should be to notify some person in authority. When should they notify some person in authority? Well, they should notify a person in authority reasonably proximate to the time that such an injury is said to have occurred. And that's one thing that we're going to investigate when we get to our AOE, COE determination. Now, critical. Says if liability for this injury is not rejected within 90 days after the date the claim form is filed under Section 5401, the injury shall be presumed compensable under this division. Okay? Let me say that again. If liability is not rejected within 90 days after the date the claim form is filled out, the injury shall be presumed compensable. So if an injured worker wants to make a claim for an industrial injury, they should make sure that they get a claim form filled out, because that starts the clock ticking for the 90 days. The claims administrator has up to 90 days to accept or reject the claim. That's why this examination that I was talking about earlier that called me today, the request for examination is within 4 months of the date of injury, just after the lapse of the 90-day time period referenced here in 5402. So now you know where 90 days comes from. It's written into the code. The presumption of this subdivision is rebuttable only by evidence discovered subsequent to the 90-day period. That's why your QME examination is generally scheduled after the 90th day. After the 90th day. Okay? The claims administrator, if they don't accept or reject the claim within 90 days, they can only rebut the presumption of acceptance or compensable by information, by evidence discovered subsequent to the 90-day period. For this reason, you'll get a call after the 90th day. Okay? Now, here's where the $10,000 rule comes to play. It says, within 1 working day after an employee files a claim form, the employer shall authorize the provision of all treatment. Of all treatment. All treatment meaning treatment related to all body parts that are listed on the claim form. So if the injured worker comes and fills a claim form and says, I hit my head, I hit my shoulder, I strained my low back, I twisted my knee, I'm having stomach upset from the stress and the pain, then the employer shall authorize the provision of all treatment to all of those body parts listed on the claim form. Okay? For the alleged injury, doesn't say for the accepted injury, for the actual injury, it says for the alleged injury, and shall continue to provide the treatment until the date that liability for the claim is accepted or rejected. Until the date the claim is accepted or rejected, liability for medical treatment shall be limited to $10,000. So let me explain this. What this section says is that the injured worker fills out a claim form today. Well, by tomorrow, the employer has to authorize treatment for all the conditions listed on the claim form, up to $10,000. Up to $10,000. That's a lot of money. That's a lot of money. Well, in order to stop the bleeding from the $10,000, what's the claims administrator's only option? The best option is to deny the claim. Is to deny the claim. And then give themselves some time and some breathing room to investigate the claim, of which they have up to 90 days to accept or reject the claim. Now, if they do neither, if they don't immediately accept or reject the claim, they can simply choose to provide treatment up to $10,000, but that could be quite costly, multiplied by hundreds and thousands of injured workers. So in these types of cases, the claims administrator's best option is to reject the claim, to give themselves some time and some breathing room, and to stop the bleeding from the $10,000. Okay? Now, let me ask you a question. Now that you understand the $10,000 rule, and now that you understand that the claims administrator is on the hook for expenses until they make a decision to either accept or reject the claim, let me ask you a question. Why, in your opinion, why would the claims administrator deny or reject the claim? Let's say that within one working day of notice of the examinee or injured worker filling out a claim form, aren't there circumstances and instances where the claims administrator immediately accepts the claim and begins to provide medical treatment under the claim? Not under 5402, not under the $10,000 rule, but begins to provide medical treatment under the auspices of the actual claim. There are those cases, correct? They immediately accept the claim. Well, what type of cases does the claims administrator immediately accept, and what types of cases would cause the claims administrator to want to deny or reject the claim? Let me ask you, if an injured worker fell off a scaffold from the second-story window and fell to the ground on their back, and it was witnessed by the supervisor and the owner of the company, okay? And then that injured worker took an ambulance ride to the hospital, and medical records from the hospital indicate that he had fractures of his skull, fractures of his pelvis, there was blood loss, there was all this injury, and the injured worker had a bona fide injury that was witnessed by credible witnesses and credible historians. Is that the type of claim that the claims administrator is going to say, no, I'm going to reject this claim, I want to do some investigation? No, that's the type of claim that the claims administrator immediately accepts, and begins to provide benefits under the claim. Not under 5402, but under the claim. Okay? Now, on the other hand, what would cause a claims administrator to want to reject a claim in order to investigate the circumstances of the claim? What type of scenario, what type of situation, what type of circumstance would prompt the claims administrator to want to deny or reject a claim? Are they going to want to reject or deny bona fide, legitimate claims? Witnessed injuries? Bona fide injuries? No. They reject and deny the injuries that have associated red flags with them. They don't deny or reject bona fide claims. They reject or deny suspicious claims, claims that have red flags, claims that cause the claims administrator to raise their eyebrow in suspicion, claims that the claims administrator is not convinced that there was an actual injury. These are the types of claims that cause the claims administrator to get out that stamp that says denied. It's not the bona fide cases, okay? So in order to stop the bleeding from the $10,000 while they investigate the claim, they simply reject it and deny it to stop the bleeding from the $10,000. That's why you get these claims. That's why you get them. You're part of the investigation. So now, many times, let's talk about the denied claim, the denied and rejected claim. Claims administrator has some suspicion about the claim, has some doubts about the claim. And so, what types of doubts exist when it comes to rejected claims? Well, how about factual doubts? How about administrative doubts? How about medical determinations, medical doubts, okay? Now let's talk about administrative doubts. Claims administrator could get a claim form on her desk that says the examinee injured himself on Saturday playing softball at the company picnic. I'm just making this up, okay? Injured himself on Saturday at the company picnic, but upon hearing this, his supervisor wrote a note to the claims administrator and said, I was at the company picnic, I was playing softball all day, we had 2 games, and Tom Smith never came to the company picnic, okay? That's an administrative, factual inconsistency, an administrative and factual inconsistency. Claims administrator learns that Tom Smith wasn't even at the company picnic, denies the claim, and begins a series of investigations. Okay, that's administrative and factual. Okay, now what's another type of dispute? How about medical determinations? Injured worker shows up and reports a back injury to his supervisor, but the supervisor reports that he heard gossip that Tom Smith hurt his back 2 days earlier racing motocross, and that actually the injury did not occur at work. Okay? Another medical inconsistency or a medical factual inconsistency. Okay? So the claims administrator has these concerns. They deny the claim, and they order a qualified medical evaluation from us, the purpose of which is to determine whether or not the injury is compensable or not. Now, this is where we as qualified medical evaluators have to be very, very careful. Okay? So, let's talk about Labor Code 4060 and compensability issues. Labor Code 4060 says that this section shall apply to disputes over the compensability of any injury. This section shall not apply where injury to any part or parts of the body is accepted as compensable by the employer. Okay? So, says if a medical evaluation is required to determine compensability at any time after the filing of the claim form and the employee is represented by an attorney, a medical evaluation to determine compensability shall be obtained only by the procedure in 4062. If the medical evaluation is required to determine compensability and the employee is not represented by an attorney, the employer shall provide the employee with notice either that the employer requests a comprehensive medical evaluation to determine compensability, or that the employer has not accepted liability and the employee may request a comprehensive medical evaluation to determine compensability. Okay? Well, let me ask you, under what circumstances would a medical evaluation be required to determine compensability? Okay? If the whole basis for the rejection of the claim has to do with the fact that Tom Smith was not even at the company picnic. He wasn't even at the company picnic. That does not require a medical determination. Tom Smith could be nearly dead. Okay? He could be injured, but if he's claiming that he hurt himself at the company picnic and he wasn't even at the company picnic, that's an administrative factual denial. Has nothing to do with medical determination. Tom Smith could come to the medical evaluator and we could find, yes indeed, he's got fractures all over his body, blown discs, sprained ankles, concussion, all this stuff, but he wasn't even at the company picnic. That type of denial does not require a medical determination. 4060 talks about those specific cases that require a medical determination to determine compensability. Are you seeing the subtle nuance of this circumstance? So really what this applies to, and what we're talking about in this discussion, are those examinees who actually have some sort of a condition, some sort of a painful condition. And our job becomes to determine whether or not that condition that they're reporting could be related to an industrial injury the way that they described the industrial injury to have occurred. Okay? So let's explore this a little bit further. Let's explore this. Okay? Let's say the examinee comes to his employer on a Monday morning and says to the employer, on Friday when I was working in the warehouse alone around 2 p.m., I was unloading the shipment of boxes and I strained my back. And I didn't really think much of it at the time, but over the weekend it got worse, and by Saturday night I was having spasms in my back. Sunday morning I could not get out of bed, and here I am on Monday morning. I can't work today, but I thought I should come in and report the injury. Okay? Have you had these types of cases before? I've had these types of cases before, and I'll share a couple of those with you. Okay? Now, the claims administrator learns of this claimant and denies the case, denies or rejects the claim. Why would the claims administrator deny or reject the claim? Well, in this instance, they deny or reject the claim because, number one, red flag, is that it was an unwitnessed incident. And number two, that the injured worker had a delay in reporting the incident. Okay, it was unwitnessed. There was no one in the warehouse to see him or witness him injuring his back. And then also, he did not report the injury until approximately more than 48 hours after it is said to have occurred. Two red flags: an unwitnessed incident and a delay in reporting. So the question for the claims administrator becomes, did an industrial injury occur or did it not occur? The occurrence or non-occurrence of an industrial injury in this case is not a medical determination, but it's a question of fact. Did it occur or did it not occur? He said it occurred, but there was no one there. He didn't report it right away. He's simply coming in on Monday morning to tell you that on Friday he had an injury that was not witnessed. In this case, the occurrence or non-occurrence of an industrial injury is not a medical determination. It's a question of fact. Okay? So, what is the role then of the qualified medical evaluator when you receive this request for examination under Labor Code 4060. What's your role? Can you put your signature on a report that says, in my opinion, an industrial injury occurred, or in my opinion, an industrial injury did not occur? How do you know? You don't know. You weren't there. What's your role? Okay? Your role in this type of evaluation is one single role. One single role. And that is to determine whether or not a bona fide medical condition exists. See, that's the medical determination. Medical evaluation is required to determine compensability. Your job is to determine whether or not an actual bona fide condition exists. And if a bona fide condition exists, is it possible that that bona fide condition could possibly be related to an incident that occurred the way that the examinee described it to have occurred? Is there a bona fide condition? The best way to reject a claim is to find no bona fide condition. Okay? Examinee comes in and says, I hurt my back lifting boxes in the warehouse. You examine them and you find they have a perfectly normal exam. You say, I don't identify a bona fide condition. If a bona fide condition does exist, is it possible that that condition could be the result of an injury that occurred in the way that the examinee described it to have occurred? Now, when it comes to these determinations, you will find that there's only two possible opinions that you can offer. Opinions that later turn out to be correct, and opinions that later turn out to be incorrect. So, for example, you can opine for an industrial injury that later turns out to be erroneous and an industrial injury never occurred, but the examinee fooled everybody, including you. Or you can opine that industrial injury did not occur, and that can be later found to be incorrect as well, as evidence and proof accumulates to support the occurrence of an industrial injury. So you can opine correctly or you can opine incorrectly. And I've done them both. And you've probably done them both as well. Well, the purpose of today's discussion is to help you increase the probability of opining correctly in these circumstances. In other words, are there some rules? Are there some principles? Are there some procedures? Are there some interviewing techniques and interviewing questions that can help us to get to the truth and to help us fashion our opinion either for industrial injury or against an industrial injury in a way that most of the time will be the correct, true, factual, and actual opinion. And that's what I want to share with you in the next section of today's discussion. So let's take a brief break here, and I look forward to being back with you in just a couple moments as we continue today's discussion on AOE, COE, the causation determination,